Yes.
In connection with item number 1, Lordship, we have filed the additional affidavit day before yesterday. It's not a part of record, Lordship. Allow me to do the record, Lordship.
We will call it today.
Today, tomorrow, Lordship, it will.
Tomorrow.
Tomorrow. It will be part of
Item number 1.
item number 1.
On the pair being made by Mr. M.K. Bora, learned counsel for the accused, list the matter tomorrow. In the meantime, call for the additional affidavit filed by learned counsel for the petitioner from the registry.
Obliged.
Yeah, please, Your Lordship. My lord, I beg to mention item number 27, my lord.
27.
27. My lord, it may
Copy this volume
diary received. My lord, it may be taken at 2, my lord. Or 2.
today.
At my lord.
Okay.
Obliged.
Okay.
May I please, Your Lordship? Lordship, I beg to mention item number 11. Lordship, the conducting counsel, Mr. M. Hussain, is not well. The matter may be adjourned for a week.
On the pair being made by Miss
G. Swami.
learned counsel appearing on behalf of Mr. M. Hussain, learned counsel for the accused, races will raise the matter after a week.
Obliged.
On 20. Victimization for listing matter. This is Zimma petition matter. My vehicle is under custody of police matter for more than
When?
3 months.
When?
10, Friday.
Friday. Okay.
Mentioning for listening for pending criminal appeal, Lordship. Matter didn't reach. Lordship, matter didn't reach in the last 4 days. The matter was kept as leftover, Lordship. So
When?
there's some urgency, Lordship.
When?
Lordship, any date, Lordship, next week,
On
Next
15,
week.
15 of the. May I please, the Lordship? Regarding mention for widow, Lordship. Tomorrow,
When?
Lordship. For widow. Widow, for
When?
tomorrow, Lordship.
Tomorrow.
Yes. Lord, I get to mention for listing on bail application, Your Lordship. If possible, my lord, by tomorrow may be taken up.
on
Very-
15, tomorrow, there will be too many cases tomorrow.
My lord,
Possible.
by tomorrow. Obliged. Wait, Lordship. Item number 13 may kindly be adjourned for that.
Item number?
13, 1C. And may kindly be after
When?
2 weeks. After 2 weeks. Lord.
Why after 2 weeks?
The party will engage senior.
On the pair being made by Mr. M. Rahman,
Emra,
learned counsel for the accused, races will raise the matter after 2 weeks.
after 2 weeks.
On 24th May,
Obliged.
Prayer for listing, my lord. Kindly matter may come up next week, anytime next week.
on
Take a
30,
date from him.
30,
Okay. But the victim for listing, criminal appeal, Lordship.
When?
On 13.
13.
13.
Okay.
my lord, this is a listing for withdrawal, my lord, kindly tomorrow,
When?
tomorrow. Obliged.
Main page also, I beg to mention item number 18, Lordship. CDS
18.
18, Lordship. Next week, Lordship.
Next week. On the pair being made by Mr.
PP Puko.
learned counsel for the accused, races will raise the matter next week.
On 15,
May I please, Your Lordship, I'm seeking for an adjournment, item number 10 from daily list.
Item number?
10, daily list, Mr. D.K. Bhattacharya is unwell, Your Lordship.
Mr.
D.K. Bhattacharya,
Your good name?
Dilmate, D. Moman. On behalf of D.K. Bhattacharya, Your Lordship.
Okay. On the pair being made by Ms. So-and-so, learned counsel appearing on behalf of Mr. D.K. Bhattacharya, learned counsel for the petitioner, races will raise the matter on
15, Your Lordship.
15. But did you inform the other side? Mr. Deuri, respondent number 2, learned counsel for the respondent number 2.
have you informed?
Yes, we have informed the concerned opposite party.
Inform.
Yes, yes.
Okay.
15, Your Lordship.
15. Okay.
Thank you. Thank you, Operator.
May I please, Your Lordship. Lordship, my prayer for listing fix criminal petition, Your Lordship, for admission also on next week, Your Lordship.
18.
In May.
17,
When?
on 17 March,
May.
May.
oh, sorry, 17 May. Yes, Friday.
Lordship.
There, please, Lordship, I beg to mention for listing, Lordship, criminal appeal, Lordship.
When?
Next to Lordship,
Next week?
yes,
Okay,
On
take a date
17.
from him.
70
oh, please.
items from daily list for motion bail application. Item number 2.
Court argument notification, my lord. FIR is case
Okay, volume two.
12 minutes. Allegation of seeking matter in the name of providing EWS.
FIR one of the, that was the incident took place on 10/10/2012. And the FIR was lodged on 13/10/2012 after 3 days. And this is the allegation that is a kidnap. So well, if something was happened on the particular day, and the lady is the mother of 2 children. Well, from the marketplace, is it possible, madam? Maybe it is for an entirely easier been taken, my lord. No manner things will come out about the kidnap, but there is no evidence of any applying force or any of the ingredients that to I believe lady will be forcibly married to any other person or she used to have some kind of a sexual relation with the other person. Nothing has been made out. So affair as this kind of there are allegations the another person also there. This Habibur Rahman. The search sheet has been filed on search sheet number 70 of 2014 on 24/6/2014. Where the Habibur Rahman has been exonerated, only my name has been there. So facts is that one of the complainant and myself, both were a cousin brother. The victim, alleged victim, she is the wife of complainant number 2. So having some friendly relations, accordingly, his wife became a good friend of me. And on which he suspicion made out his mind and some said that I have some illicit relation with the lady, on which some warrants has been broke up. Subsequently, that lead to filing of criminal cases also. Ultimately, the lady became intolerable to the behavior of the complainant, and she
So
decided
under whose provision search sheet was submitted?
it is one of the 366 file. But the section was not mentioned in the search sheet. Otherwise, police provision doesn't file it is not mentioned. Only basis of the FIR that they may not case has been registered as 366. So,
Okay,
my-
we'll issue notice at this instance.
Yes, my lord, the lordship may issue, but one clear is there, my lord. Because my lord, there was no summons was issued to my address. Because my address, my lord, I am staying in Bodumuni, this is Golaghat, my lord. But address there is showing in somewhere else. So notice was not came to me. So I have nobody has received my notice. But in spite of that, my lord, court issues their PNA, my lord. So I paid that, my lord, till then, my lord, PNA not maybe recalling by this order.
Where is that order?
This is, my lord, I have mentioned, I did in para, in my grounds, my lord, 14 also I have mentioned. Order copy I have, my lord. It is not enough, because these are already
Visible copy নহয়.
But I copy is
Here it is
no,
mentioned.
type copy mentioned. I have. Type copy I have. These are the orders, my lord. First order that was on 20/10/2022 it is issued. But practically no summons has been issued to me. I have never received any summons.
So here shows that PNA issue now.
Everybody also my recalling of this bill. Notice may issue to the respond number 2 also after his entering the lordship will decide to be there. The only facts is one of the cases covered under the one of Hazarlal case. This one is still only fact. The only subsequent only getting up decision has been relied on that. Well, category number 1, 3, 5, and 7, very much applied to in my case.
Where is that order?
This
By
is,
which the court below has issued proclamation against you?
this is 20/10/2023.
Page number?
Please.
This is my page at 19.
No, that order.
Order that was not annexed, but I have just given it. I need it.
No, that is here. Page 14. You have not typed it.
Case 14. PNA.
Yes, my lord, case 14, Your Lordship.
পুরানা এডিপিস পূর্ব পুরানা আমার পূর্ব দিছে পিপি
Heard Mr. P. Mohanto, learned counsel for the petitioner, and also heard Mr. B. D. Gogoi, learned additional PP for the state respondent. In this petition, under section 384, 482, read with section 397 and 401 of the Code of Criminal Procedure, the petitioner has brought for quashing the FIR dated 13/10/2012 and the search sheet number 70 of 2014 dated 24/6/2014 arising out of Lahorighat PS case number 203 of 2012, corresponding GR case number 1230 of 2012 under section 366 IPC pending before the court of learned subdivisional judicial magistrate within bracket S Morigaon. And also the order dated 20th/10/2023, 17/11/2023, 21/12/2023, 18/1/2024, 27/2/2024, and 19/3/2024, passed by the learned subdivisional judicial magistrate S Morigaon in GR case number 1230 of 2012. It is to be noted here that by the impugned orders dated so and so, the learned court below has issued proclamation against the present petitioner. Peruse the petition and the documents plus on record. Let notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 2 be taken by registered post with AD and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Gogoi learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to Mr. Gogoi during the course of the day. Recess will call for the record. Scan copy of the record from the learned court below. And till returnable date, execution of the PNA issued by order dated 20th/10/2023, 17/11/2023, 21/12/2023, 18/1/2024, 27/2/2024, and 19/3/2024 stands state till returnable date. List after 4 weeks.
Item 51.
Wait, please, your lordship. Lordship, I am the petitioner in person who is the case, your lordship. Kindly peruse the page number 12. Page number 12 of the paragraph number 6. Complainant name, where it mentioned my name, your lordship. And the case was registered on WPS 6 number 3/24 on my FIR, your lord. And sections are registered against the FIR name accused persons is 294, 506, and 352, which is mentioned in paragraph number 2. Page 12. And FIR is page number 15, your lordship. I am victim of this case, your lordship.
Pardon?
I am victim of this case, your lordship, but the
How can you appear for your own case?
Yes, Lordship, I am the petitioner in person in this case. I may allow for submit this case.
Pardon?
I may allow for submit this case, Your Lordship.
Gogoi, can she appear for her own case?
On case she can appear, my lord, not as advocate, my lord, in person,
In a person, Your Lordship.
in person.
And the page number 15, Your Lordship, FIR made by me, I am the informant of the WPS case number 3 of this 24.
Then nalag.
No, she prayed for quashing her own FIR.
Whether you want to push your own affair?
No, Lordship.
But here, this affair lost by you.
Yes, this FIR lodged by me, Your Lordship.
Now you want
And Lordship,
quashing of
kindly,
this affair.
no,
Then?
Your Lordship, kindly peruse the page number 25. Here made me accused
Then-
and sent to trial along with the accused person.
তুমি এইটো আগত কিয় দেখুৱাইছা তেনেহলে তুমি
Number 25,
যিটো এগেইনষ্টত আহিছা সেইটো দেখুৱা আগতে
charge sheet has been submitted against the informant with accused person. Page 25,
25.
and page number 29, Your Lordship.
So charge sheet is submitted against you.
Against me and with the accused person, and send me the trial along with the accused person, Your Lordship.
And you are the informant of this case also.
Lordship, in charge sheet, there have been mentioned, registered against us under section 160 of IPC. Page number 29. The last para.
Item 2 next. 25. This is charge sheet.
29, page number 29.
No, no. All full sheet, huh? Get two for us. All to the F2. Here, fair to go. Here, fair to.
There have no any FIR, Your Lord.
Huh?
There have no any FIR. In my case, Your Lordship, I have lodged an FIR on 19/1/24, and the incident has committed with me on 3/1/24, and I have lodged an FIR before the WPA, and case has been registered on WPS case number 3/24, Your Lordship. After then, they have the IO has filed the charge sheet within a short period, Your Lordship, and make me accused in this charge sheet, and Your Lordship send me trial along with the accused person, Your Lordship.
No, no. Without FIR, can I get charge sheet?
That is, it is only
No,
one
in
case is
the
raised
in the charge sheet at page number 24, it has been mentioned that you are the complainant informant of the case.
Yes, I am the complainant informant of this case, but make me accused. How to make me accused by the IO, Your Lordship? It is completely illegal. I am the victim in this case, Your Lordship. But she has not submitted any final report. Directly, she has submitted the charge sheet and make me accused forcefully and send me to trial along with the accused person. How can make me accuse, Your Lordship? Because I have the first informant in this case, and there have no any close cases also. Only on my FIR, only one case is registered. That is the WPS case number 3/24, where the sections are registered against the accused persons is 294/506 and Your Lordship 352 of IPC, which is mentioned in page number 12.
তোমার কেছত তোমাকে accuse
Oh,
নাই দিলে।
completely illegal, Your Lordship. IO has made me accuse, Your Lordship. But I have the informant in this case. And page number 24 of the search sheet, paragraph number 8, name of the complainant informant Miss Anjana Medis. In the same search sheet, how can she make me accuse, your lordship?
No, no, it should is
Page 24.
is 25, name accused,
page
search
24.
sheeted, accused, Topon Sutia. Then particulars of accused persons, search sheeted, Topon Sutia, not Anjana Medi.
They're mentioned, page number 25.
25, yes, top.
Number 1 and number 2,
Top.
name Anjana Medis. For the both persons, and the page number 29 of the last para, in course of investigation, the evidence has been found against both the informant and FIR accused for committing offense under section 160 IPC. However, no incriminating materials or evidence incriminating commission of offenses under section 294, 506 to 352 IPC, as well as in the FIR is found during course of investigation. I therefore submit the case in search sheet against both informant and accused and FIR LS accused person under section 160 of IPC for facing trial. How can proceed, your lordship?
Third, Miss A. Medi, petitioner in person, and Mr. B. Gogoi, learned additional PP for the state respondent. In this petition under section 482 CRPC, the petitioner, Srimati E. Medi, has prayed for causing the criminal proceeding of PLC case number 822 of 2024, arising out of all open PS case number 03 of 2024 under section 294, 506, 352 IPC. And the search sheet dated 38/1/2024, number 02 of 2024. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by the petitioner, present petitioner, on (19/1/2024). Whereas the petition and the documents placed on record, let notice be issued to the respondent, returnable in 4 weeks. Mr. Gogoi, this respondent number 2 is a police officer.
Yes,
So you can represent her.
yes, we made it.
However, no formal notice is required to be issued to the respondent since Mr. B.B. Gogoi, learned additional PP, appears and received notice. However, extra requisite copy of the petition may be furnished to him during the course of the day. Recessal call for the record from the learned, scan copy of the record from the learned court below. Interim pair of the petitioner will be considered only after receiving the record from the learned court below. Let the record come, we will consider your interim pair.
52.
My lord, this is for 38 application, my lord. FI says number 12. My lord, already 2 person arrested and the arrested accused persons have already been alerted on bail by your lordship, my lord. FI is page number 12. Cyber. Yes.
So why you were appending arrest in connection with this
These
case?
are the relatives of my lord, arrested accused persons, my lord. Petition number 1, 2, 3 are the wife and sons of arrested accused person Manul Head, and petition numbers 4 and 5 are the relatives of arrested accused person Akibul Islam, my lord.
But does CD come? We'll see. Gogoi CD on? Yes, Mr. Boisha, CD on?
Lordship, yes, cyber.
Cyber, cyber PS.
Cyber Lordship.
15
15.
items for admission.
And sorry,
How the main accused came to be discharged?
I obtained the certificate copies, my lord. Abdul Ghani, my lord.
Pardon?
Abdul Ghani, the name of the accused, my lord.
The contraband substances were recovered from your position.
No, it was recovered from the second chamber of a truck, my lord.
Yes, it
am the
was
driver.
driven by you.
I am the driver of the vehicle.
Yes.
The person who has been discharged is the owner of that vehicle, my lord. without the knowledge of the owner, that
No,
cannot be
no,
made, my lord.
you are not pleading his case now.
Yes, my lord. And my lord, the person who has been discharged, he has given a statement to the police, my lord. Mostly that statement should be there in the scanned copy. But you will also may kindly have a look at the last 4-5 lines of that statement, my lord. That's been recorded by police.
No, no, how do you satisfy the requirement of section 37?
No, yes, because searches have been submitted, my lord. Already searches is submitted, my lord.
No, that's all right.
Yes, my
You were to satisfy the requirement of section 37 NDPS Act.
No, because the search has been submitted, the trial is going on. No case has been examined till today, my lord.
No,
So the bar of section 37 will not come, my lord.
why?
As because the search has been submitted, my lord.
No, merely because Sarsit is submitted a prima facie case is established against you.
I'm claiming.
And besides, the trial court has also a prime charge against you.
Yes, my lord. But till today, no witness has been examined, my lord.
Oh, why?
That I cannot say, my lord, why the witnesses have not come. I'm.
No, merely because witnesses were not examined, is it the ground to enlarge you on
I'm
bail
claiming,
in a case
bail.
where commercial quantity is involved?
I'm claiming bail for on the basis of parity, my lord.
What parity?
As because the co-accused has been granted bail, my lord, by the lower court below.
Who is co-accused?
The person who has been once he was solicited, my lord.
Yes.
But he has been discharged. But he has given a statement to the police. And his statement has been recorded. You
No,
also
no,
may
that
kindly have a
person
look-
has been discharged.
Yes, my lord. But you also may kindly have a look at the his statement, what he has stated before. police.
Whose statement?
The person who has been discharged, my lord.
No, his statement is of no value.
He himself has stated before the police that I am the person who is involved in this case. Me along with my son is involved in this case. That is the statement he has given to the police, my lord.
That statement is not admissible.
Yes, my lord. But even after that, for
But you have been found in possession of the commercial quantity of contraband substance.
no, I was engaged as a contractual driver, my lord. I am not regular driver of that vehicle.
That is, we are not concerned with you are regular or not regular.
Yes, my lord.
But the thing is that the contraband substances were found in your possession.
But I
You have to satisfy the requirement of section 37.
But I'm already languishing in bail for more than 1 year, my lord.
Maybe,
But trial, as because the trial is not.
but in the case of Mohit Agoral, NCB versus Mohit Agoral, Supreme Court stated that length of detention is no ground to enlarge you on bail.
But I have some. But we have got certain decision of this Honorable High Court also, where the co-accused has been granted bail on the basis of parity, my lord.
No, where he has been granted bail. Who is accused? Court has granted bail.
No, he has been discharged. No, I'm sorry, my lord.
So you are not in the same footing with that accused,
My lord.
who has already been discharged. Discharging a accused and granting bail to a accused is a different aspect.
But prima facie, my lord, there are sufficient allegations against the owner of the vehicle also, my lord. Even after that, he is-
No, we are not dealing with his case now.
Yes, my
He
lord.
has already been discharged by the trial court.
Yes.
Unless the state prefer a revision petition against that order, we cannot consider that aspect.
Yes.
So you were to satisfy the requirement of section 37. How do you satisfy it?
Can you be taken up at 2, my lord,
Today?
today?
Okay.
Item 16.
May please, your lordship. The petitioners are behind the bar for the last 14 months, lordship. Wildlife case, lordship, second bail application, lordship.
Who is for the state? Okay.
Last occasion also swap time, lordship. Wildlife, lordship.
Wildlife.
Oh, wildlife.
Wait for some time.
Lordship, then at 2 PM, lordship.
2 PM.
Oblige, lordship.
17.
Kindly pass over the matter for time being. My lord, always time being there, taking time being, lordship, how long will wait for them, lordship?
Okay, wait for some time.
Nineteen. Item 19.
Not the 439 application, my lord. Today,
Hmm.
36 days behind the bar. my lord.
30?
36. 36.
She did not receive, my lord.
My lord, he was arrested in another case, my lord. And in that case, my lord, the accused has already enlarged
In
on-
this case, he has been shown arrested.
Yes, my lord. And he is languishing in jail hazard since 17/3/2024. And my lord, his earlier bail application also pending. Because of non-availability of bails, my lord. His earlier petition was nature of offense. And nature of offense are also same, my lord. Earlier case, my lord, 2 accused has already enlarged on bail on 19/4.
In this case,
No, in first case. But his bail petition is still pending, my lord, because of non-availability of bails.
non-availability of
Bails. Honorable Justice, my lord, MK Kolita, my lord, he granted bail and he was not available for last 2 weeks. "36 days and
yes, Gogoi.
Today diary not received, lordship.
my lord,
So sorted then Friday.
Yes,
my
yes,
lord,
my lord.
similar
Friday.
offense, my
Friday?
lord,
Yes.
earlier, my lord, in
Okay,
first
wait till Friday. Third, Mr. S.A. Ahmed, learned counsel for the accused, and Mr. B.B. Gogoi, learned additional PP for the state respondent. Mr. Gogoi submits that he has not received the case diary and pressed for granting him 2 days time. Pair is accordingly allowed. Recessal is the matter on Friday.
On 10. Item number 20. Item number 20.
None appears for the accused on call. This
They
the
also
matter
Friday.
after 2 weeks, after 1 week.
Item 21.
Twenty-one, my lord, charge it submitted.
Charge number
Yes. Charge sheet number 96/23, dated 30/6/23.
you were on interim bail. Under section Gogoi,
That details is not here, my lord, only the charge sheet number and date that is there.
whether against the present petitioner or not.
That details is not here, my lord, only that number and date they have mentioned.
Otherwise, the witnesses have been examined.
Yes, some of the examined, my lord. And present petitioner, he appeared before I, my lord, he has given statement. Moi Gorusuri Kajo Kurishigi. That is.
Heard Mr. A. Dekal, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Uluwani PS case number 55 of 2023 under section 380 IPC. This application under section 438 services preferred by applicant. Ziaur Rahman for grant of PRS bail. It's to be noted here that a noted case has been registered on the basis of one FIR lodged by one Sopon Das of Uluwani PS. No, Sopon Das on 11/1/11/2023. The sense of allegation made in the affair dated so and so is that on 1/11/2023 at around 2 p.m. some unknown person entered into his cowshed and stolen one black stroke white colored cow and one red colored cow. And they have also stolen one white colored cattle from the cowshed of his neighbor Binod Kumar. Then, having heard some commotion outside his house, he came out and found some unknown person carrying the cattle in a vehicle bearing registration number AS02DC stroke 0739. And also he had seen one white stroke red colored KTM motorcycle fleeing away along with the vehicle. And later on he came to know that few days back from the cowshed of one Vikas Sharma of number 4 Rongzuli, 2 cows were stolen. And also cows were stolen from the cowshed of one Udit Narayan. Mr. Dekka, learned counsel for the applicant, submits that this court by order dated 22/12/2023 was placed to grant the privilege of interim periods bail. And pursuant to said order, the applicant had appeared before the IO and cooperating with the investigating agency, and therefore Mr. Dekka submits that the interim order dated 22/12/2023 may be made absolute in the same terms and conditions. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced the case theory before this court and confirmed appearance of the applicant before the IO. Mr. Gogoi further submits that the IO has collected sufficient incriminating materials against the applicant, and some of the co-accused are yet to be arrested, and therefore Mr. Gogoi has opposed the petition. However, to a pointed query of the court, Mr. Gogoi submits that the IO has examined some witnesses here in this case. But having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Gogoi, learned additional PP. Case diary indicates that the applicant had appeared before the IO and cooperating with the investigating agency. Further, it appears that the IO has made substantial progress in the investigation of this case. And though the IO has collected some materials in support of the allegation made in the FIR, yet, in view of the progress of investigation and in view of the cooperation being extended by the applicant, his further custodial detention seems to be not warranted here in this case, and therefore the interim order detention so is hereby made absolute in the same terms and conditions. Case diary is returned.
Item numbers 25 and 26.
Sorry, Lordship, the item 20, Lordship. It's on Friday, Lordship.
Not now as the last item.
Please, your lordship. In item number 25, the petitioner is on interim lordship.
Yes, he has appeared, my lord.
Here and submitted his statement.
26, there is no injury.
Check, already the things has been recovered, check.
So what is the stage of investigation, Google?
Investigation, my lord, here also some other vehicles yet to be apprehended, my lord. That's item number 25, Abdul Basit, he was a driver, my lord, carrying the goods, my lord. And another, my lord, item 26, he is my lord, connected with my lord, along with another vehicles, my lord, in my lord, carrying those, my lord. goods. So, my lord, there is material against my lord, item 26, my lord. And there is no interim in 26. 25, there is interim, he appeared, he was driver.
Heard Mr. S. Besbarua, learned counsel for the applicant, and Mr. B.V. Gogoi, learned additional PP for the state respondent. This prayer number 2 and 3. For order dated 22/2/2024. Mr. Besbarua, learned counsel for the applicant, submits that the applicant was granted the privilege of interim period bail by order dated 22/2/2024. And thereafter he had appeared before the IO and cooperating with the investigating agency. And therefore, Mr. Besbarua contended that the interim order dated so and so may be made absolute in the same terms and conditions. Whereas Mr. B.B. Gogoi, learned additional PP, has produced the case that is before this court and submits that the applicant had appeared before the IO and his statement is also recorded. But in view of the submission of learned advocates of both the parties, this court is inclined to dispose of this application by directing. This court is inclined to. The case diary indicates that the IO has indicates that the applicant had appeared before the IO and cooperating with the investigating agency. And further, it appears that the IO has achieved some progress in the investigation of this case. And in that view of the matter, custodial interrogation of the present applicant is found to be unnecessary here in this case. And therefore, it is contended to, therefore, the interim order date is so and so if we have made absolute in the same terms and condition. Gogoi, can I see the case diary?
Yes, Lord.
In pair number 26. No, item number 26. Or Mr. You were in the 26 also. Item number 26 also.
Yes,
Is Besbarua, learned counsel for the applicant.
he was, my lord.
And also, heard Mr. B.B. Gogoi. Is apprehending arrest in connection with Howley PS case number 8 of 2024 under section 380 411 34 IPC. This application under section 438 services preferred by applicant Firuz Ali for grant of PSP. Thereafter, pair number 2 and 3. So what is your submission here?
Here the submission is that he was not present, not involved in this. He was in fact on that day, he was in Guwahati working on a construction site, daily basis.
Mr. Besbarua, learned counsel for the applicant, submits that the applicant is innocent and no way involved with the offense alleged in the FIR. And that at the relevant time of occurrence, he was at Guwahati and working under a construction company. And therefore, and further, Mr. Besbarua submits that the applicant is ready to cooperate to the investigating agency. And therefore, it is contended to allow this petition. On the other hand, Mr. B.B. Gogoi, learned additional PT, has produced the case diary before this court and submits that the IO has collected sufficient incriminating materials against the present applicant. and therefore Mr. Gogoi has opposed the petition. Thereafter, it is having heard to Case ID indicates that the IO has collected sufficient incriminating materials against the present applicant. Investigation is going on and stolen article which indicate one of the RRU is yet to be recovered. And in view of the materials collected so far in the case area as well as progress of investigation, this court is of the view that this is not a fit case where the privilege of peerless bail can be extended to the applicant, and accordingly, the petition is thus dismissed. Case area be returned.
Abdul Rahman matter pertains to the transportation of cattle. He's the owner of the cattle, Abdul Rahman. I have annexed the cattle passage to in my petition, page 10 on
The present applicant is the owner of the cattle,
owner of the cattle.
and from where he purchased it.
This is purchased from the Shipsagar Rajmai lawsuits. I have annexed the cattle passage receipt lawsuit. Page number lawsuits 10 on lawsuits.
But how far these receipts are genuine?
Earlier applicant I am paid for the interim lawsuit so that he can produce the document so that I can verify.
And Gogoi, you received the case ID.
Yes, there he received, my lord. He is not, and there is no interim, my lord. So his statement is not here.
No, that's all right. Is there any material against him?
Material, my lord, here it is showing that he is the owner. But verification, my lord, regarding those papers, my lord, that report is not here, my lord.
Page 15 lawsuit, you will kindly see.
heard Mr. Sutia, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Bosisto PS case number
842/23.
842 of 2023 under section 379 for 1134 IPC. This application under section read section 13(1) of the Assam Cattle Preservation Act 2021. Read section 11(1)D of the Prevention of Cruelty to Animal Act 1960. This application under section 438 services is prepared by applicant Abdul Rahman for grant of previous bail. Above noted case has been registered on the basis of an FIR lodged by ASI Bipul Chandra Deka of Jorabad Police Outpost on 28/12/2023. The sense of allegation made in the FIR dated so and so is that on 27/12/2023, while he was attending night patrolling duty at the area under the Jorabad Police Outpost, he has intercepted one vehicle bearing registration number NL01K 7143 at about 4:30 p.m. from Guwahati side to Barnihat, carrying 26 numbers of live cattle illegally without any document. Mr. Sutia, learned counsel for the applicant, submits that the applicant is the owner of the cattle and he had purchased the same from a Rajmai weekly animal market, and the relevant receipts were enclosed with this petition as Annexure 2 series from page number 10 to
Page number 14 onwards, Lordship.
page number
14 onwards, Lordship.
what is page number 10 then?
Page number 10, Lordship. It's a forwarding, Lordship.
Huh?
Sorry, Lordship. Page 10, Lordship. I'm sorry, Lordship. I'm sorry, Lordship. Page 10, Lordship.
Page 10 up till
Yes, okay. Yes, my bad.
Lordship, page 10 onwards, Lordship. 26 number to receive, I have an Lordship.
page 10 onward till page number 61. And that the applicant is innocent and no way involved with the offense alleged in the FIR and he is also ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced the case there before this court and submits that the applicant is the owner of the cattle. And is there any material against him? Any other material?
My lord, 2-3 person already arrested in this case. All those person, my lord, they are saying that, here, my lord, their statement says that Ami Pohora di Thaku pass the vehicle, my lord, from that area. My lord,
That's
that
all right,
is-
but whether anybody whispered any word against
No, that stolen from my house, it not such type of.
কি করলো line টো? Owner of the cattle. And except that no other incriminating materials are available against him in the case diary. Having heard the submission of learned advocates of both sides, I have carefully gone to the petition and the documents placed on record and also perused the case diary with the assistance of Mr. Gogoi, learned additional PP. In view of the materials collected so far in the case diary, as well as the progress of investigation and also the submission of learned advocates of both the parties, and further considering the Annexer 2 series, inclusive the petition from page number 10 to page number 61, this court is of the considered opinion that custodial interrogation of the applicants in the interest of investigation seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in connection with Vasistha PS case number so and so, he shall be released on payers bail on his executing a bond of rupees 50,000 with 1 surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following 3 conditions. Last condition, he shall not leave the jurisdiction of CJM Kamrup M without prior permission. Number 1, he shall appear before the IO within a period of 10 days from today and produce all the relevant documents, that is Annexer 2 series from page number 10 to 61 before the IO for verification. In terms of this evidence, this was of CDB return.
I am obliged.
Item 29.
438 pages resolution. Earlier CD was called for.
Yes, CD received. Herein interim measure appeared before I.
Is there any material against him?
Material, my lord, they are owner of CSP, my lord. And we suspect that they might be, my lord, committed this offense, my lord. 268, that is, my lord, Aadhaar card, except that is.
Petitions are not the owner of the CSP.
So have you appeared before the IO?
Yes, sir.
When?
It's on 13.
13-3. Heard, Mr.
Alone.
Learned counsel for the applicants, and also heard Mr. B. Gogoi, learned additional PP for the state respondent. This para number 2 and 3 of order dated 11/3/2024. The learned counsel for the applicant submits that this court wide order dated 11/3/2024 was placed to extend the privilege of interim periods bail to the applicants. And pursuant to the said order, all the applicants have appeared before the IO and cooperating with the investigating agency. And therefore, it is contended that the interim order dated 11/3/2024 may be made obsolete in the same terms and conditions. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced the case before this court and submits that some materials are collected against the present applicants by the IO. However, Mr. Gogoi confirmed that all the applicants have appeared before the IO pursuant to order dated 11/3/2024, and they have been extending cooperation with the investigating agency. After having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the case area with the assistance of Mr. Gogoi, learned additional PP. It appears that the applicants have appeared before the IO cooperating with the investigating agency. Further, it appears that the IO has as if substantial progress in the investigation of this case, and their custodial interrogation in the interest of investigation seems to be not warranted here in this case, and accordingly, the interim order dated 11/3/2024 is hereby made obsolete in the same terms and conditions.
Deeply obliged.
Case there will be returned.
Item number 30.
Yes, Lordship, my lord, on instruction of my clients, my lord, I may be allowed to do this.
Your good name?
M. Ali.
Mr. M. Ali, learned counsel for the applicant, submits that he has instruction to withdraw this application. Accordingly, Mr. Ali is permitted to withdraw this application. And the same is thus disposed of on withdrawal.
I have a question.
31. Item 31,
None appears for the applicant on call, raise this is the matter after 1 week.
item 32,
Your lordship. Last occasion, notice was issued, your lordship. This is a FOCSO matter.
Notice was issued.
FOCSO.
So, as per notification dated 15/3/2024, you have to deposit your notice in the office of the public prosecutor.
I have taken steps, your lordship.
কত লইছে আপুনি আমাৰ অফিচত দিছে নে ও ৰেজিষ্ট্ৰি অফিচ
I have taken steps, your lordship.
At
Acknowledge.
the section,
Yes,
but as per notification, you have to submit in the office of the public prosecutor.
I have taken 2 steps, your lordship, by way of
বাট ইনি ৰেজিষ্ট্ৰি
registry as well as OC.
No, not registry.
So,
And this, do you have any copy of the notification dated 15/3/2024?
I have the notification, your lordship. One.
So notice has to be served through the public prosecutor office. Then public prosecutor has to obtain a report from the officer in such jurisdiction LPS in respect of service of notice.
এটা দিব দিছিল অৰ্ডাৰ মতে কৰিব লাগিব অৰ্ডাৰটো যেনেকে দিছে কোৰ্টে
No, itu so this as per this notification,
Yes, my lordship.
notification number 17, you have to take step. You submit it in the office of the public prosecutor, Guwahati High Court.
I'll do the needful, my lordship.
Office note dated 4/5/2024 indicates that neither AD card nor unserved notice is returned to the section. The learned counsel for the applicant submits that he will take fresh step upon the respondent number 2. Person to order dated 19/4/2024. And in view of the notification number 17 dated 15/3/2024. Within a period of 2 working days from today. Prayer is accordingly allowed. List the matter after 1 week.
20, Monday, 20.
From which PS?
Kazigaon. Skokagan.
Kazigaon. Okay.
Item 33,
Yes, charge it.
Yeah, please, Lordship. Lordship, I may be protected till I appear before the trial court, Lordship. Only one for equals on the Rapa is on the anticipatory bail and allowed by this honorable court. And I annexed that order, Lordship.
In this
Annex
case,
3. Yes, Lordship.
in the same case,
Yes, Lordship. Annex 3, Lordship, page number 17.
Charge it for আগত পিছত charge it হৈছে 31/3
And the Lordship, I have no role in this case, and I am not a FIRNM accused, Lordship. Only on the basis of the suspicion, the police are searching me. And the Lordship also on the.
yes, Gogoi, what is the search sheet number?
charge sheet number 21/24 dated 31/3/24 and his name is there, my lord, Konkon Das.
Heard, Mr.
Yes, they will also.
Learned counsel for the applicant. And Mr. B.B. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Mosalpur PS case number 8 of 2024 under section 406 IPC. This application under section 438 services prepared by applicant, namely Anupam Rabha. No, sorry, what is the name of the applicant?
Konkon Das Lodge.
Konkon Das for grant of free arrest bail. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Rabzar Musahari on 1/2/2024. The sense of allegation made in the FIR dated 1/2/2024 is that one bidding to borrow asked the informant to purchase one Yamaha R15 motorcycle from Mosalpur Yamaha dealer on 15/10/2023. And he paid the down payment amounting rupees 66,937 and also paid a sum of rupees 8,000 being the EMI for the first month. And thereafter he stopped making payment of EMI and also stopped picking up his phone call. Mr. Devi, learned counsel for the applicant, submits that the applicant is innocent and no involved with the offense alleged in the FIR, and one of the co-accused has already been granted the privilege of PRS bail by this court by the order dated 11/3/2024 in AB number 631 of 2024. And that the present applicant is also stands in the same footing and is ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. Whereas Mr. Gogoi, learned additional PP, submits that he has not received the case ID, as in the meantime investigation stands completed and charge sheet number 21 of 2024 dated 31/3/2024 is submitted against the present applicant. But in view of the submission of learned advocates of both the parties, this court is inclined to dispose of this application by directing the applicant to appear before the learned trial court and to apply for regular bail. In the event of filing such an application, the learned trial court shall consider the same in accordance with law. Within a period of
To appear on 24th May.
24. Till appearance of the applicant before the learned trial court, this court is inclined to extend the privilege of interim PRS bail. Accordingly, it is provided that in the event of arrest of the applicant in connection with Mosalpur PS case number 8 of 2024 under section 406 IPC, the applicant shall be released on interim PRS bail on his executing a bond of rupees 50,000 with one security of like amount to the satisfaction of the arresting authority. The book privilege is, however, subject to the following three conditions. Number one, he shall appear before the learned trial court on or before so and so. Number three, last, he shall not leave the jurisdiction of learned CJ Mosalpur Baksa without prior permission. In terms of this AB instance disposal.
Obliged.
Item number 34 by Bhesi Mode.
My lords, I must apologize, my lords, because of the elections, my lords, I have to appear online. My lords, today we already have an interim.
Have you appeared before the IO?
Yes, my lords.
When?
It's on 10th, 9th or 10th, yes.
Gogoi, you received the case.
Diary not received today.
Acha.
My lords, one issue is also there that co-accused, this matter was before court number 24. And today, the co-accused have also matter fixed anticipatory bail before court number 24. But this matter has been listed before
Whether
this.
case ID is available there
Yes, my
or
lords.
whether the case ID is called for in that case.
Yes, my lords.
Gogoi, is it
Court-
available there?
We have no any information, my lord. We may take at 2, my lord, at 2.
Two.
Yes.
Okay, we'll take it up at 2.
Okay.
Yes. In the meantime, he confirmed the availability of this case ID.
Much obliged, my lords.
35.
35 also diary not received.
It is not, it's an entire lordship.
Mr. B.B. Gogoi, learned additional PP, submits that he has not received the case ID and press for granting him some more time. Here is allowed. SSL list the matter on
Lordship. 17.
17. Till then, interim order dated 5/4/2024 stands extended.
Obliged.
36.
Here also diary not received. Interim is there.
Same order. Date
24th May.
24th.
Obliged.
Till then, interim order dated 8/4/2024 stands extended.
Obliged. 27.
CD receipt also.
Immediate period also, CD was called for. But whatever in this case, an agreement was signed between the applicant and one company, Disnet Wireless Service, for installation of ground-based mobile tower. The allegation in the complaint, because initially a complaint was filed, on the direction of the Honorable Court, police treated the complaint as a FIR and registered a case under section 379 IPC. Here, the agreement you should find at page.
Lordship said, but only thing is that my duty to point it out, and I pointed out. If your lordship said this way, I'll accept it. But here, my lord, the important thing is that, my lord, even the SLP is probably not given to us. The leave petition for which he has filed a delay, my lord. Because leave, then SLP, then the appeal will.
You furnish the petition to him.
Lordship.
How about the episode? Correct.
Yes, what is the ground for delay?
What is the ground for delay? We have already mentioned in para 2 of the petition, lordship, at page 2, lordship. There is a delay of 206 days in filing the appeal, lordship. The ground, lordship, is stated in para 2, lordship. May I read the para 2, lordship? The applicant stated as per Article 114 of the schedule of the limitation at the period for filing of appeal under the Code of Criminal Procedure 90 days for date of order. The impugned judgment in special case number was passed on 31/10/2017 and the certified copy of the judgment and order was received on 2/11/2017. The appeal is filed on 27/7/2018 and hence there was a delay of 206 days in filing the related appeal. The delay in filing the appeal is not intentional, but it occurs due to the procedure invoked for obtaining the approval from Ministry of Personnel and Training, Government of India. As per the laid down procedure, the proposal for according approval for filing appeal is required to be examined by the conducting law officers of CBI branch, HIO, HOP, Senior Public Prosecutor, DLA, Head of Zone, ALA, CBI New Delhi, Director of Prosecution, SD CBI, and Director of CBI. Again, after receiving approval of the Director, proposal was sent to the Ministry of Law and Justice, and thereafter the final approval was accorded by the Government of India Department of Personnel and Training, which is received by the CBI Shillong Branch on 14/5/2018. A copy of it has been annexed, lordship, as Annexure 1. And lordship, the sequence of event in the incident case are followed. We have narrated the entire sequence from which your lordship will come to know that why the delay has occurred, lordship. These are the sequence of event, lordship. On 31/10/2017, Learned Counsel for Special Judge CBI so acquitted the accused so from the liability of special case number so arising also. On 31/10, The application for obtaining certified copy of judgment was submitted by the applicant. Read Lordship, on 3rd November 2017, the certified copy of judgment was received by the applicant officer at CBI, ACB Shillong. On 3/11/27, dealing assistant time session placed the certified copy with note in the court diary file. On 7/11, conducting PP of CBI was requested to forward its comment on the judgment and order on 31/10/2017. On 13/11, Lordship, comments of conducting law officers along with the limitation performed was received by the branch. On 21/11/17, comments of the head of branch and the conducting law officer was sent to the HOZ-NE CBI Guwahati. On 22/11, Lordship, HOZ Northeast Guwahati marked the file to DLA Northeast Kolkata for comments. On 28/11/17, DLA Northeast Kolkata submitted its comments and marked the file to HOZ-NE CBI Guwahati. On 30/11, file received by Zonal Office CBI Guwahati. On 1/2/2017, HOG Guwahati placed his comments and marked the file to SDCBI. On 11/12, file received by SDCBI New Delhi. On 23rd/1/18, SDCBI New Delhi marked the file to Director of Prosecution CBI New Delhi. On 25/1/18, Director of CBI marked the file to SK Sharma ALA CBI New Delhi for comments. On 6/18, SK Sharma ALA CBI New Delhi submitted his comments and marked the file to DOP CBI New Delhi. On 8/18, OP Verma, Director of Prosecutions, submitted his comments and marked the file to SDCBI. On 21/18, SDCBI New Delhi submitted his comment and sent the file to the Director CBI New Delhi for approval. On 24/2/2018, Director CBI New Delhi approved the file, the criminal appeal before the higher forum against the judgment and order dated 31/10/2017 and marked to SDCBI RA New Delhi. On 26/5/2018, SDCBI RA New Delhi marked the file to JD Northeast. And then on 28/2/2018, Joint Director NE marked the file to DIG Range CBI NEZ Guwahati. On 15/3/18, DIG Range CBI NEZ Guwahati marked the file to HOB CBI Shillong for necessary action. On 19/3/2018, file received from HOB CBI ACB Shillong marked the file to dealing assistant to prepare the draft proposal for DOP for approval of the Government of India for filing criminal appeal before the Honorable High Court, Guwahati. On 19/3/18, dealing assistant submitted the draft proposal and marked to HOB CBI Shillong. On 23/3/2000, proposal letter was signed by HOB CBI ACB Shillong and sent the Undersecretary, North Block, New Delhi for according approval. On 14/5/2018, letter of so-and-so dated so-and-so received from the LP Sharma Undersecretary conveying the approval of the GOPT Government Doctor for filing. That is on 14, it was approved. On 14/5, the dealing assistant placed the file to HOB CBI Shillong with noting. On 15/5, HOB so-and-so marked the file PP to prepare draft appeal petition condoning the delay and specially to the appeal. On 18/5, PP CBI Shillong submitted draft petition. Then on 19/5, HOB CBI Shillong being not satisfied with the draft petition prepared by the newly appointed PP marked the file to so-and-so. So, Lordship, these are the sequence of events, Lordship, for which there is a delay, Lordship. Ultimately, on Lordship, 27/7/2018, appeal petition was along with condonation of delay petition and special petition are filed, Lordship. So these are the reason, Lordship. These are genuine reason, Lordship. We have no intention to cause any delay in filing the appeal, Lordship. These are the procedural lapses, Lordship. Therefore, Lordship, this delay and so forth. These are my respectful submission.
Yes.
Well, probably your lordship is taking a break, my lord. Yes, now. Shall I proceed or we'll take a break? Well,
Yes, you can continue.
I have
We'll
no
finish.
issue.
So, my lord, my first ground is that he has not filed this delay petition in connection with a criminal appeal. He has filed his petition in a revision against acquittal, which is not maintainable. Because in all prior portion in the whole of the petition, it is stated that he is praying for filing a revision petition. And I have showed it, my lord. In paragraph number 1, my lord. Of his condonation petition, my lord, he states that the appeal is pending How can the appeal be pending, my lord? That the applicant CBI Anti-Corruption Branch Shillong has filed an appeal under Iman and or under Iman of the against the impugned acquittal order dated Iman passed by the learned special judge, additional Chanmari Guatin, by which the learned court below has acquitted the accused for the said criminal appeal is pending disposal. It's not admitted, my lord. How can it be pending for disposal?
No, but you
No,
submit
what-
on the
my lord,
grounds
these are the-
shown by him.
My lord, these are shows not application of mine, just because one person has been acquitted.
No, we are not concerned with
Then
that,
what I
whether
have to
they
do?
have applied their mind or not. We are on the ground
No,
for
that
delay.
is the main ground, my lord.
No, no.
Whether there
No,
was delay genuinely or due to laches and negligence. If it is delayed due to laches and negligence on the part of the office and the officer concerned
You
and the
come to your,
prosecution, then my
this-
lord, it
your
cannot be
affidavit.
delayed, exonerated, my lord.
You come to your affidavit.
Yes, my lord. I've stated all these at para 4 and the relevant portion is para 4. So they don't know what petition they are filing, my lord. One must know if he seeks equity, he must come with clean hand and with the narrative, my lord, as to on the genuine grounds. Then I have stated that the Everman made it para number 1 that the said criminal appeal filed by the applicant CBI is pending disposal according to law. It's not disposable, it's not taken into board, it is not taken into consideration also. Only the criminal appeal serial number is given. That much I agree and admit. Now, if we come to their own manual, my lord, I have given the narrative, I have given the step by step how a delay petition is to be dealt with by the CBI. The CBI has got its own manual. Your lordship will kindly see the or chapter 23 of the CBI manual 205. I have written in para 5, my lord. I'll take your lordship to that today. There's a regards to the statement made in paragraph 2 of the condonation of delay petition is stated that the time taken by various officers of the applicant CBI, he has given the chart. That chart I will show also how routinely it was mentioned. In taking decision to file the appeal against acquittal of the accused respondent is totally unreasonable and not satisfactory. It will be worthwhile to point out herein that chapter 23 of the Central Bureau of Investigation Crime Manual 2005 prescribes the procedure for filing appeal revision extra challenging the acquittal discharge. The applicant CBI is required to follow the said procedure prescribed on the said chapter 23 of the CBI Manual 2005. In the instant case, the applicant has not followed the laid down procedure guideline as prescribed under chapter 23 of the said Manual 2005. Admittedly, the applicant CBI has not stated as to when they receive the certified copy, because the first point of counting the delay will be when the certified copy was received. From there only, because if there is delay on the part of the office, my lord, then my lord, that can be condoned itself. Admittedly, the applicant CBI has not stated as to when they received the certified copy of the impugned judgment dated 31/5/2017 from the court, but they have simply mentioned that the certified copy of the impugned judgment dated 31/10 was received by their office on 3/11/2017. Their office they mentioned, I am deprived of because I have not get that's why I pointed out, I have not got the copy of the judgment, my lord. So I don't know when they have received the certified copy from the office. So there is a huge gap of 31/10 and 3/11, my lord. And thereafter, if the process was immediately initiated, then how it took more than a period of about 9 months in filing the appeal? It was filed after certified copy, 9 months, my lord. Order Rule 23.4 of the said chapter 23 of the CBI Crime Manual clearly states that the branch senior PP should ensure that the certified copy of the judgments in the condonation petition itself per se will not give them the right to get it condoned. File movement is an infra office. We don't know whether it was rightly been stated or correctly stated or not. So all this request to be examined.
Heard Mr. M. Haloy, Learned Special Public Prosecutor for the CBI and counsel for the applicant. And also heard Mr. Zaid Kamar, learned senior counsel assisted by Mr. Learned counsel for the respondent. Argument concluded. Order reserved.
Lordship, I have supplied the copy, judgment and the LP, Lordship. I have
Okay.
supplied.
That may be reflected.
Yes,
What do you think?
Lordship, that may be reflected, sir. And my lord.
Gogo, you received the case, eh?
Yes, the diary receipt, yes.
Yes, FIR is at page number
Page number 11, sir.
11.
21 C, my lord. My lord, only I am the registered owner, my lord, and before the incidents, my lord, the said vehicle has been sold out to another person, my lord. There is an agreement also, my lord, I been.
Where is the document?
My lord, page number 15,
Is it registered?
registered owner, my lord, I am.
No, no. The document is registered or non-registered?
Not authorized by the both the parties, my lord.
Pardon?
By the parties, my lord, executed before the notary, my lord.
No, whether it was a registered document?
Not registered, my lord.
Not registered.
Page number 15, my lord.
Pardon?
Page number 15, my lord. Incidence was, my lord, 5/10/2023, my lord, and date of execution of affidavit, my lord, 3/6/2023. The purchaser is to pay the monthly EMI, therefore, my lord, I cannot hand over the title of the vehicle. Page number 17 is the relevant portion, my lord. The parties are also, my lord, has been paying, my lord, monthly EMI to the concerned bank, my lord. Bank statement I have annexed also, my lord.
So the occurrence took place on 5/10/2023 and this agreement was executed on 7/10/20.
Not 7, my lord, 3/6/2023.
Hmm.
And 7/10, my lord, it was certified to be true, my lord.
Hmm.
Originally, my lord, kindly top left hand side, my lord, page number 15, my lord,
Page number?
page number 15. Serial number 216036/2023. Serial number. Thereafter, my lord, signature of the notary, my lord. 3rd June 2023, my lord.
This is only agreement,
Agreement.
not sale deed. Agreement, agreement for sale.
So how do you satisfy the requirement of section 37 NDPS Act? Because the quantity of contraband substance allegedly recovered from your possession is of commercial quantity. It is 1,728
kg.
28 kg. How? No answer.
But I have no possession. I have no possession with the vehicle, my lord. I have no connection with the driver. I have no role.
No, maybe, but on the basis of this agreement, can it be said that the vehicle was not in your possession?
But, if
Hmm?
the CD reveals anything, my lord,
Hmm?
if the CD, my lord, reveals anything.
There is a bank statement also, my lord. He is paying the EMI.
And signature in your affidavit and agreement are also different. Hmm? Yes, Gogoi, any other material in the case diary?
My lord, that vehicle is blacklisted by DTO Tripura. That notice there, my lord, in the diary. Earlier also, I think, my lord, some other cases against this vehicle. EMI of the vehicle paying by the present petitioner.
Hmm. Till today.
Yes. The last here shown by 30th September 23, last installment.
Heard Mr. F.L. Oscar, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Kaline PS case number 499 of 2023 under section 20 within bracket C of the NDPS Act. This application under section 438 CPC is referred by applicant Sultanuddin for grant of PSP. Be it noted here that above noted case has been registered on the basis of an FIR lodged by SI within bracket P Pranjal Lakra of Kaline PS on 5/10/2023. The sense of allegation made in the FIR dated so and so is that acting on a tip-off on 5th of October 2023 at about 2:15 AM, the informant along with other police staff have intercepted one vehicle bearing registration number TR01AR-1815, which was coming from which was coming towards Meghalaya. Meghalaya, and after checking the vehicle, they have recovered 1,728.23 kg of ganja, suspected ganja, and seized the same in presence of witnesses. Mr. Locker learned counsel for the applicant submits that the applicant is a registered owner of the aforesaid truck and he purchased the same from Tata Finance Limited and he paid EMI at the rate of rupees. What is the EMI?
99,180
Per month?
per month.
90?
99,000.
99,000? Where it is mentioned in the annexure 4?
The agreement, my lord. Page number 17.
But you have annexed this.
No, to the finance company. $10,000?
Not paying equally. What are the check installment? You don't know. He's not paying equally.
EMI and then no, and that by agreement dated 3/6/2023 the present applicant had given the vehicle to one Nilu Sharma on the condition that he will pay EMI at the rate of rupees 99,180 to the finance company. And that the applicant is no way involved with the offense alleged in the FIR. And he is ready to cooperate with the investigating agency and therefore it is contended to allow the petition. On the other hand, Mr. B.B. Gogoi learned additional PP referring to the materials collected so far in the case area submits that the present applicant is the owner of the vehicle from where the contraband substances were seized and as per his own document at annexure 4 of the petition, he had paid EMI till 1st of October, no, till 30th September 2023. And that the IO has collected sufficient incriminating materials against the applicant, and therefore Mr. Gogoi has opposed the petition. Having heard the submission of learned advocates of both the parties, I had carefully gone to the petition and the documents placed in record and also perused the case diary with the assistance of Mr. Gogoi learned additional PP. It appears that the informant has seized 1,728.23 kg of ganja from the position of the from the vehicle bearing registration number TR01AR1815. And admittedly, the present applicant is the owner of the aforesaid, registered owner of the aforesaid vehicle. Though Mr. Loskor, learned counsel for the applicant, submits that he had submits that pursuant to annexure number 3, an agreement the applicant had given the said vehicle to one Nilu Sharma, yet the said agreement is not an registered agreement and it is not a sale deed. Not a sale deed. Whereas the materials collected so far in the case diary indicates that the present applicant is the owner of the aforesaid truck, and the said truck was blacklisted by North Tripura DTO on 8th of October 2022 for transportation of illegal substances. Further, it appears from the case diary, materials collected in the case diary, that there are sufficient incriminating materials against the present applicant. Indisputably, the quantity of contraband substances recovered from the vehicle is commercial quantity, and the applicant has failed to satisfy the requirement of section 37 of the NDPS Act, that he is not guilty of the offense and that he will not commit any offense while on bail. Under the aforementioned facts and circumstances, this court is of the view that this is not a fit case where the privilege of peerless bail can be extended to the applicant. Accordingly, the petition is dismissed. Case there will be returned.
Candidate number 2 for motion.
Yes, Lordship, here diary is available.
Available.
Yes, yes.
So is there any material against the present applicant?
Here, my lord, co-accused statement, my lord. He is saying that false document, my lord, prepared by my present petitioner with the help of one another person, my lord.
By the present applicant, present accused,
Yes, yes,
Vivek Mandal.
yes. It did, it did. Yes. It did.
But he was arrested on 30/3/2024.
Yes, that is.
So whether further custodial detention is required in the interest of investigation?
Yes, my lord, thoroughly
Interrogated.
admitted also everything.
What is the stage of investigation?
Investigation, my lord, that two main accused already arrested, 2%.
Hmm.
And other, my lord, official witnesses, their statement recorded, my lord.
Hmm.
Is document not prepared by the proper authority, that is.
Hmm.
One of the accused already granted bail.
Pardon?
One of the accused already granted bail.
That
Granted
co-accused,
bail.
co-accused.
Okay, heard, Mr.
J. Ahmed.
J.A. Ahmed, learned counsel for the accused, and also heard Mr. Baby Gogo, learned additional PP for the state respondent. This application under section 439 services prepared by accused Vivek Mandal, who has been languishing in jail Hazard in connection with Vasistha PS case number 205 of 2024. Since 30/3/2024 for grant of bail. Is to be noted here that Vasistha PS case number so and so under section so and so has been registered on the basis of one FIR lodged by one B2 Poddar on 29/3/2024. The sense of allegation made in the FIR dated 29/3/2024 is that one Vivek Mandal of Lal Ganesh has issued one fake EWS certificate to the informant and thereby cheated him, and one racket is involved in issuance of such fake and fraudulent certificates. The learned counsel for the applicant submits that the accused submits that the accused was arrested on 30/3/2024, and since then he has been languishing in jail Hazard. And that one of the co-accused, namely Binit Burton, has already been granted bail by this court by order dated 30/4/2024 in BA number 1198 of 2024. And that the accused is ready to cooperate with the investigating agency and therefore it is contended to allow the petition. Whereas Mr. Devi Gogoi, learned additional PP, has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the present accused. However, Mr. Gogoi submits that the accused has been thoroughly interrogated by the police. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case area. With the assistance of Mr. Gogoi, learned additional people. The case area indicates that the IO has achieved substantial progress in the investigation of the case. Relevant materials have already been collected, and the main culprits have also been arrested. And one of the co-accused has also been enlarged on bail by this court by order dated suspense. But having considered above, especially the length of detention, especially considering the length of detention, further custodial detention of the accused may not be warranted here in this case. No, seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned chief judicial magistrate Kamrupen, the accused be enlarged on bail. Case will be returned.
Timing item 3.
To deliver the consignment to this person. And from my position, when they were intercepted me, they were intercepted me at the toll plaza. Sonapur toll plaza. He was intercepted. Lordship will find at page number 35 of the final complaint from para 54. He was intercepted there on 6/2/2021 at 19 hours, but from his position, no contrabands were recovered. Lordship. To that regard, Lordship, I would like to place the judgment, Lordship. Yes, sir. Lordship will find the paragraph number 13, Lordship.
Paragraph?
Paragraph 13, fourth line, Lordship. Further, large number of tablets have been seized by DRI admittedly contain herbs/medicines meant to enhance male potency and they do not attract the provisions of NDPS Act. Most importantly, none of the tablets were seized by the prosecution during the course of search conducted either at the office or at the residence of A4 at Jaipur on 16/3/2020. Reliance on printouts of the WhatsApp messages downloaded from the mobile phone and devices seized from the office premises of A4 cannot be treated at this stage as sufficient material to establish a link between him and A1 to A3. When even as per material to establish a live link between him and A3, whenever as per the prosecution scientific reports in respect of said devices is still awaited. In absence of any psychotropic substances found in the conscious position of A4, we are of the opinion that mere reliance on the statement made by A1 to A3 under section 67 of the NDPS Act is too tenuous a ground to sustain the impugn order dated transactions. Subsequently, that was allowed. And I found one of your lordship's judgment lordship, order lordship. Because five witnesses examine lordship. For 5 witnesses at no point of time in their lordships implicated this person that contraventions were recovered from this person. Yes, so, Lordship passed this order on 7/3/2024. A similar nature of case, Lordship, based on Tufan Singh, Lordship.
Yes, Mr. Kyle.
Lordship, with regard to examination of witnesses, only my learned friend is correct. Lordship, but one correction is there. On 2nd of May 2024, witness was present, but he could not be examined due to paucity of time. And next date is fixed. Lordship, this is reflected in the order. I have gone through the order of the learned trial court on the website. Other statement is correct. 4 witnesses been examined and cross-examined. 5, partly he was chief was examined, and thereafter 2 dates there was no witness was present. On 3rd day he was present, but he could not be examined. Now, Lordship, the role of the petitioner is Lordship may come to page 42, paragraph 88, 89, 90, 91, 92 of the bail application.
Paragraph number?
Paragraph 89, 88, page 42 of the bail application. Is the part of the complaint.
42.
Page 42.
Yes.
Paragraph 82 to 93. 88 to 93.
Yes.
That as per the voluntary statement by 4 arrested accused, namely Sapan Kumar Malaka, Pradeep De, Viton Das, and Ajay Saha, admitted in their voluntary statement that Syed Asik Alam is the receiver of the seized ganja, 2843.79 kgs of ganja. Sapan Malaka disclosed 2 mobile numbers of Asik Alam, number so and so. That 4 arrested accused persons, namely so and so, admitted that they had delivered the consignment of ganja once to Asik Alam on 6/12/2021. Then paragraph 90, that given the statement by Asik Alam on 7/2/2021, he admitted his guilt of the trafficking of ganja and he had done this illegal business of ganja at the direction of one person named Boro. Further, Syed Asik Alam admitted that he had received four times of consignment of ganja with the help of Boro and sent this ganja to Bihar, West Bengal, and other truck through Boro. Boro facilitated him and he only know the supplier of the seized ganja. As per the given voluntary statement of Syed Asik Alam.
But can you convict him on the basis of this material?
Lordship, may please to see paragraph 92 and 93 also. Beside this, Lordship, some other materials are also on record, Lordship. And Lordship knows that trafficking of gaja or narcotic, Lordship, is a organized crime.
No, that's all right, but you establish the link of the accused with the offense.
Trial is going on, Lordship.
Hmm?
More witnesses have been examined. And Lordship, he was arrested on 8/2/2020.
Yes.
He was arrested on 8/2/2021.
So you could not recover the mobile phones of the accused.
But CDR has been analysis and it was found that he was in.
Whether that CDR is supported by any
That is a matter of trial, Lordship.
65B certificate.
That is a matter of trial, Lordship.
The matter of trial, that's all right, but whether any certificate was enclosed,
That Lordship, at this stage, Lordship, I mean, not in position to.
then whether this CDR can be considered
Lordship, it is
as
to-
evidence.
It is to be proved. Unless if it is not proved, then definitely it will not be taken into evidence.
No, in one or two judgments, Supreme Court has stated that this cannot be a ground,
No, Lordship,
the CDR.
if it is proved by the service provider,
Mm,
then it can be.
mm.
Normally, if they fail to prove, if they fail to,
No, there are some judgments of Supreme Court. Yes, available with you.
Right now, I don't have Lordship, but kindly see the page number 50, the list of the witnesses. No person from the service provider made witness in this list.
Yes. How can you establish it?
that Lordship, I cannot make any comment at this stage.
Pardon?
I cannot make any comment at this stage.
No, they can because their rights are violated, no?
No, Lordship, please to see one thing in this point. Lordship, Supreme Court in 2005. I'm reading the relevant paragraph. I placed the judgment before your Lordship. This is by the three judges bench. It is total law that the personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedure established by law. Under the criminal law of this country, a person accused of an offense.
No, that's all right, Mr. Kyle. You see, if there is no other material, can you, on the basis of the statement of the co-accused,
Lordship,
you can convict him?
no, Lordship, at the end of the trial, if the prosecution failed to, then he is entitled to. But whether he has been rightly arrested or not, that is to be seen by your Lordship at this stage. Whether other materials can be considered while considering the bail.
No, why not?
Lordship,
Why not?
I have submission to that matter also, Lordship. I can place some judgment to that on that point also, Lordship.
When?
Tomorrow?
Tomorrow. Kabir, how many matters are there tomorrow?
Tomorrow at 2, Lordship.
Achha. Okay, you produce the judgment tomorrow. And you produce the judgment on
Yes, sir.
CDR.
Tomorrow at
Like,
2 if this is possible.
Huh?
At 2, Lordship, possible.
Heard Ms. S. Nargis, learned counsel for the accused, and Mr. S.C. Kyle, learned standing counsel for the NCB. List the matter tomorrow as part heard.
Much of it. Item 34 by VC mode.
Yes, ma'am.
Here, my lord, diary is not available. Another case was listed in another court, my lord, but they are also diary not available.
Not available.
Not available.
Okay, we will extend the interim protection till production of the case diary. Mr. B.B. Gogoi, learned additional PP submits that he has not received the case diary and press for granting him some time to produce the case diary before this court. Here is allowed. The SSL is the matter on when?
COVID. 27? Yes.
27. Till then, interim order dated 5/4/2024 stands extended.
Much obliged.
Turning item 53. Yes, CD not available, my lord.
There, my lord, my interim prayer may be considered that the other accused has been already under on pre-arrest bail, my lord, interim bail. My lord, I have annexed all my academic documents, starting from the mark sheet, birth certificate, and the registration certificate. मतलब एक-एक की प्रति दी।
Here in this case, we search whether CD is available in the PP office or not. Also, CD has been returned back.
Returned.
Returned also.
The other case, my lord, it was fixed, it has.
Let the CD come, Lord,
31/5. It is fixed on 31/5, my lord. I have supplied the copy, order copy, my lord. Let it also come, and in the meantime, my lord, I may protect it, my lord. I'll produce all the documents before the IO. IO can take the, my lord, report from the concerned authority, whether it is genuine or not. Otherwise, my lord, I have the original documents, my lord, may Peru.
No, unless those documents were verified by the police from the concerned institution, can it be said that, can we place reliance upon them?
Yes, that's why, my lord, I may be protected, my lord, as the other petition is.
Okay, then, fixing sort that we can call for the case, I think. When? Monday?
Okay.
Next Monday? Mr. Locker learned additional PP submits that he has not received the case. Accordingly, it is provided that Mr. Locker shall produce the case before this court on Monday without fail.
13th.
On that day, if he fail to produce the case, we will consider it.
Item number 39 for orders.
Lordship, Lazima Court order dated 19 to 24, Lordship. Service is complete upon respondent number 2, Lordship. This is special leave petition, Lordship.
Order dated 19/2/2024 of the laws in my court indicates that service upon respondent number 2 is completed. But nobody appears on behalf of the respondent number 2. No, but the respondent number 2 remain unrepresented today. Part Miss
Sharma, Lordship.
Learned Counsel for the applicant. No, for the petitioner, and Mr. Locker learned additional PP for the state respondent number 1. List the matter for admission hearing on when?
On 28,
Short date,
on 21st week.
21st.
Much of.
Now 40.
Please, Your Lordship, my lord. Was a condonation petition, my lord, of 190 days, my lord.
Please, Your Lordship. And for the private respondent, Your Lordship, I was supposed to file the affidavit, your Okalatama, along with the written objection, Your Lordship. But due to the ensuing election, Your Lordship, the respondent could not come to Guwahati, Your Lordship. On Monday, Your Lordship.
Monday, next Monday.
Yes, Your Lordship.
When can we-
On 15th.
$15. Okay, heard Mr.
NK Boroma.
Learned Counsel for the applicant and Mr. P.S. Locker, learned additional PP for the respondent number 1. And Mr.
I.H. Laskar.
I.A. Hussain
Laskar.
Laskar, learned counsel for the respondent number 2. Mr. Laskar, learned counsel for the respondent number 2, submits that he will be filing his Ukalatnama and his response on next Monday. Wednesday. Here is according to law. Rest is the matter on Wednesday.
Item 41.
Yeah, please, Your Lordship. This is an appeal against
Appearing on behalf of
Ashish Das Gupta. Ashish Das, A Das Gupta.
A. Das Gupta, learned counsel for the learned senior counsel for the applicant. Rest is the matter on when?
On 28. Item number 49.
My lord, as per occasional status, 4/5/24, my lord, service report regarding respondent number 2 is awaited, my lord.
So how we have taken is that?
My lord, on that demand.
No, by registered post or through the PP.
My lord, through PP, my lord.
Through PP. Office note dated 4/5/2022. No, 2024 indicates that service report in respect of respondent number 2 is awaited. Accordingly, it is provided that provided that the learned additional PP shall obtain a report from the jurisdictional PS in respect of service notice upon respondent number 2. The office note also indicate that scan copy of the LCR has not been received. Rest is shall issue reminder to the learned trial court for transmitting the record without further delay. Unless the matter after
After 2 weeks.
2 weeks.
On 22nd. Item 54.
May I please, Your Lordship? Lordship may kindly peruse the last order dated 22/02/24, Lordship. Lordship, last paragraph, accordingly, the petitioner will take. Accordingly, the petitioner will take steps for service of notice on respondent number 2 by paper publication in 2 widely circulated newspapers, one in Assamese Daily newspaper and another in National English newspaper, by showing the next date of appearance of the said respondent on so and so, and thereafter shall file an affidavit to that effect. Lordship, we have done our part and we have also filed the additional affidavit. Now only remains, Lordship, last line, Lordship. Service of notice on respondent number 2 through the jurisdictional police station, which shall be routed through the office of the learned public prosecutor. So that remains, Lordship. Lordship, I kindly direct my learned friend so that he can obtain the service report from through the police, Lordship, as per this order, Lordship.
Okay, I heard Mr. Mishra, learned counsel for the petitioner. And Mr. P.S. Locker, learned additional PP for the state respondent. Mr. Mishra submits that an affidavit regarding service of notice upon the respondent number 2 has been filed. The respondent number 2 through paper publication has been filed. And further, Mr. Mishra submits that by order dated 22/2/2024, it was directed to take step upon respondent number 2 through the jurisdictional police station also. Through the office of the learned public prosecutor, but no report has been received in respect of service of notice upon respondent number 2 from the office of the public prosecutor, learned public prosecutor. Accordingly, it is provided that Mr. Locker, learned additional PP shall obtain a report from the officer in charge jurisdictional PS in respect of service of notice upon respondent number 2. Place the matter on
27 May,
Lordship,
sorted.
22nd May.
22nd May.
Timing item 20.
I'm obliged, Lordship.
Yes,
So Lordship, the shown arrest case, Lordship, today is 38 days, Lordship. Total cases will be granted bail.
Locker, you received the case diary. Not received. Mr. Locker, learned additional PP submits that he has not received the case diary. Accordingly, it is provided that Mr. Locker shall produce the case diary before this court on Friday, Monday.
Diploma.
Without fail.